Today's lecture continues the discussion of economic and social rights, focusing on some of the challenges to these rights and the responses to those challenges. That is, in effect, what we will be talking about, as you can see from the lecture overview, and we'll focus in on a number of distinctive challenges and different possible responses to those challenges. There's no one settled response. This is an area of international human rights law that is somewhat in flux, but we'll explore in particular the response of one of the so-called treaty bodies, the Committee on Economic, Social, and Cultural Rights. And then in the next lecture, we'll consider a response by a national court in South Africa. So I want to begin by reminding you of the four distinctive features of ESRs that we extracted from Article 2 of the Covenant on Economic, Social, and Cultural Rights. I've listed them here on the slide. And I asked you to think about what challenges might arise as a result of these four distinctive features. And I'd like to suggest to you that there are four challenges that arise as a result of these features. First, a universality challenge. So economic and social rights, some might argue, are not really universal rights in the nature of rights that are in international instruments such as the Universal Declaration, because, given the terms of Article 2, they vary according to each country's level of economic development and how much international aid or assistance it receives. Taking this argument to its logical extreme, a right that means different things in different places is not or should not be a human right. That's one challenge. A second is what might be called a political process challenge. And because, as previously discussed, affirmative measures are generally needed to realize ESRs, that action requires the allocation of limited resources, and that's generally done by elected officials, legislators. And that in doing this, the elected officials will often be required to negotiate and compromise over exactly how much resources to devote to any particular ESR. And so those sorts of negotiations and compromises are, the argument would continue, or according to this challenge, inconsistent with the idea that rights are fundamental entitlements of every human being. In other words, they can't be negotiated away. A third potential challenge might be called the vagueness challenge. So recall that ESRs, according to the Covenant, are to be achieved progressively and over time. Given this progressive or evolutionary application of the law, it's impossible to say whether a state is satisfying its legal obligations at any particular moment in time. And that's inconsistent with the notion that ESRs provide at least a minimum level entitlement necessary for human survival for every human being. The fourth and final challenge might be termed the justiciability challenge, and this is one that focuses on courts. The argument would go as follows. Violations of rights require remedies. Those remedies need to be legally enforceable in court, but when it comes to ESRs, judges do not have the institutional capacity or expertise or perhaps the political legitimacy to award such remedies, which would in turn require governments to allocate limited resources in particular ways. And so if you have rights that don't have judicially enforceable remedies, that is a fundamental challenge to thinking about ESRs as human rights. Now, having identified these four challenges, I want to begin to discuss some responses to those challenges. So first, one very basic response would be to develop a more specific or precise legal framework that clarifies the obligations of states in order to address the distinctive features of ESRs. In other words, Article 2 of the ICESCR, which you saw in the previous lecture, and you'll see in a moment in this lecture, could be developed with greater normative precision, and that would respond to at least some of these challenges. Now, you might be wondering who might actually develop this kind of legal framework. Well, multiple actors might do this. They could be national legislatures, administrative agencies, or national courts, as well as international human rights experts. And indeed, it's entirely possible that these different actors could develop different approaches to this particular issue. And that might create some interesting synergies as the actors relate to the frameworks that other actors have developed, or it might create the possibility for conflicts. For now, I want to introduce you to the framework that was developed by international human rights experts, and specifically the Committee on Economic, Social, and Cultural Rights, or the CESCR. This is yet another treaty body, the treaty body for the ICESCR, composed of 18 independent elected experts from all regions of the world, and it does many of the same sorts of functions that we have seen with regard to other treaties, including the adoption of so-called general comments that interpret the treaty and provide guidance for all states parties. In 1990, this treaty body adopted a general comment to address in more detail the obligations of states parties under Article 2 of the ICESCR. And I've copied for you Article 2 again here for your reference. In 1990, the Committee on Economic, Social, and Cultural Rights adopted General Comment number 3, which provided additional guidance and interpretation on Article 2 of the ICESCR, which you see on the screen before you. Before we analyze that general comment, please take a moment to pause the lecture, read over General Comment 3, and then we'll proceed. So I want you to notice one basic feature of General Comment number 3, and that is that it distinguishes between immediate obligations that all states parties must satisfy and progressive obligations that can be achieved only over time and in light of available resources. This distinction makes it possible to identify whether there might be some indelible core, if you will, of ESRs that might not be subject to some of the same ambiguities or resource constraints as ESRs on the whole. So what might some of these immediate obligations be? Well, I've highlighted in this slide some of the paragraphs from General Comment number 3, which identify some of these immediate obligations as discussed by the committee. So no discrimination relating to ESRs. That's something a government can do right away, regardless of resource levels. Take steps toward full realization. The government can, in other words, start a process moving forward by taking specific, concrete, and measured or deliberate steps. Governments can also provide judicial remedies for ESRs that are capable of being applied immediately by courts and judges. And finally, they can, and perhaps more controversially, ensure to everyone a minimum essential level of each of the rights in the ICESCR. And this is often referred to as a minimum core obligation of every state party. These would be immediate obligations that states would undertake to satisfy at the time they ratified the covenant. That does not, however, mean that that is the sum total of the states parties' obligations to the individuals within their borders. On the contrary, there would be progressive obligations, this tracks the language of Article 2, that would, according to the committee's General Comment number 3, be achieved progressively over time. And this would be to move toward full realization and prevent backsliding or retrogressive measures. So the movement has to be expeditious and it has to be effective. Recognizing that resources might be limited in many instances, the state party would need to strive to ensure the widest possible enjoyment of each of the rights in the covenant under the circumstances that it finds itself in terms of resources and levels of economic development. And finally, in making these resources available, the state should give special consideration and protection to vulnerable members of society, vulnerable groups, and do so through adopting low-cost targeted programs. This is a framework that has become quite influential over time, the distinction between immediate obligations and progressive obligations. In subsequent general comments, the Committee on Economic, Social, and Cultural Rights has analyzed each of the rights in the covenant in greater detail, and it has further developed the framework of identifying which state party obligations must be satisfied immediately and which can be achieved progressively and over time. The influence of these general comments is quite widespread. They have been cited in a variety of different contexts, including perhaps most notably in domestic courts in response to lawsuits seeking to enforce ESRs as they are protected in national constitutions. And in the next lecture, we'll look at one such domestic court decision. One last point I'd like to make about ESR general comments before concluding, and that is a typology of obligations developed by the committee known as the Respect, Protect, and Fulfill framework. Here the committee goes further than general comment number 3 in identifying, in the context of a variety of different ESRs, where governments must respect or refrain from interfering with the enjoyment of rights. That's a negative obligation. Protect, meaning prevent third parties from interfering with the enjoyment of the rights protected in the covenant. So that would be an obligation similar to the obligation we saw with regard to CEDAW to take affirmative measures to prevent violations by private actors. And finally, and perhaps most expansively, to fulfill, to adopt measures that help to fully realize the achievement of each of the rights protected in the ICESCR. We'll look at additional dimensions of these negative and positive obligations in the next lecture. For now, I'd like to leave you with some sources for additional information regarding how economic and social rights have been applied in different national settings.